All right, let's get started. I'm hoping I won't have to go to a part three. We'll see. I added one item to the agenda. We'll talk about that in a moment. In addition, I also want to talk about the FHDS, the Fire Hardening and Defensible Space Advisory. So I'm going to open up with that. And I want to bring you I want to answer a few questions. I'm getting a lot of questions, and I found out that there's some misinformation being put out actually by the state of California, of all things. And I want to sort of clarify some of the confusion. And at the end of talking about the FHDS, if anyone has any questions about that form, I'll open it up. Lindsay will monitor the chat and we'll check to see if there are questions. If there aren't, then we'll close that out and then we'll open up with the challenges that you're facing today in the real estate market, especially paying over appraisal and how to structure that correctly, how to add a buyer to a transaction. That's happening a little more frequently, perhaps helping people qualify, but it's frequently done incorrectly. And then finally, how to correctly cancel a transaction. Don't want anybody to get in trouble selling a property twice. All right, so let's talk first about the Fire Hardening and Defensible Space Advisory. The Fire Hardening and Defensible Space Advisory and Disclosure, this is a statutory disclosure that must be made in certain circumstances and cannot be waived and carries an absolute right of rescission. Like many disclosures, there are specific circumstances where this disclosure is required and other situations where it's not required. So I'm going to go through it real quickly and pay some particularly attention to one particular paragraph 4 at the end, because that is where most of the confusion is. So this form is an advisory, a disclosure, and an addendum all at once. And if you remember from the last time we talked about this, I highly recommend as a listing agent, you include this form in your counter offer, because you want the buyer to assume any responsibilities to getting inspections if the seller is not legally required to get them prior to transfer. So I'll explain that a little bit more in a moment, but I would recommend that all listing agents counter this form back to a buyer and filled out correctly, of course. Okay, so the first part of the form, I won't spend much time on that. It's the Fire Hardening and Defensible Space Advisory portion, and it talks about the law's applicability and where to locate information, and it's pretty straightforward. Not a lot of questions about that. The second paragraph is the fire severity zone disclosure, and the default is the home is in a high or very high fire hazard zone. That's why you're giving the disclosure. And if it's not in a high or very high fire zone, you're not required to give the disclosure. But you could give it as a advisory to the buyer. Some sellers are doing that, and I actually recommend it for Fallbrook and Valley Center type properties. Most of them are going to probably be in a fire zone anyway, but even if they're not, this is not a bad idea as an advisory. Because it carries a statutory right of rescission, this form should be given early in the transaction within that 7-day window. The fire hardening disclosure itself is contained there, and the law applicability, you must give this form if the specific conditions exist. And the first is it's 1 to 4 residential units constructed before 2010 located in either a high or a very high fire zone. And then that must be, oh, and you're also required to do a TDS. If you're exempt from a TDS, you're exempt from the fire hardening and defensible space advisory requirement. Okay, so the defensible space compliance does not include the construction prior to 2010. So you want to give this form regardless of the construction of the date of construction of the property, but you only need to complete the top half of the form if you were built prior to 2010. And so the bottom half of the form is where most of the problems exist, and that's the defensible space requirements and the compliance. And there are basically 4 options. The most common option is going to be option B1, and that is there is no local ordinance requiring proof of compliance with defensible space. So it's important to note that right now you must comply with defensible space, period, if you live in a high fire zone or a very high fire zone. So you must comply with the ordinance. But this form doesn't talk about compliance with the ordinance. It talks about compliance with providing proof of compliance, because that is required. And it is not required in the state law. So there's no local ordinance requiring proof of compliance is going to be by far the most common option. In fact, Carr said more than 95% of all transactions throughout California are going to probably, B1 is probably going to apply. Again, the key word here is requiring proof of compliance. I often explain it, it's similar to low flow plumbing fixtures. Right now in the state of California, every residence is supposed to have low flow plumbing fixtures, but it is not a point of sale requirement. So if I own a house that does not have low flow plumbing fixtures, I can sell it. Now I have to disclose 2 things. One, I have to disclose that you're supposed to have low flow plumbing fixtures in the house. And number 2, I don't have them. But there's no requirement to put in low flow fixtures as a point of sale requirement unless specifically stated in a local ordinance. Now, interestingly enough, much of LA and San Diego, city of San Diego, does include local ordinances that require low flow fixtures to be installed as part of a point of sale requirement. But much of San Diego County, there's no point of sale requirement for low flow fixtures. Same with proof of compliance for defensible space laws. You're supposed to maintain defensible space around your property if you're in a fire zone or a very high fire zone. But the concern is, does the law require proof of compliance? I don't know if I mentioned or not, Truckee, according to Carr, Truckee is the only locality that requires proof of compliance, or certainly it's a major area, and that's up near Tahoe, I believe. I haven't confirmed LA County yet for the RE/MAX All-Pro agents. I will by the end of the day. I have confirmed County of San Diego. In the County of San Diego, to the best of my knowledge, and I've actually read the ordinances, there is no requirement to prove you're in compliance with defensible space laws as to sell your property. So B1 is going to be far more common. Now if the buyer, if documentation is required, the buyer can get it within 1 year of close of escrow, and if the local ordinance allows that. Again, we don't even have a local ordinance in San Diego County, and I don't believe LA has one either. Now, B2 would be apply in those unusual situations. I don't know if unusual, but somewhat rare situations where the seller did a recent remodel and as part of the permitting process was required to prove he was in compliance with defensible space law requirements. So if you remodeled a home recently in a high or very high fire zone, it's very likely the local building department also wanted you to document that you were in compliance with defensible space as part of the building permit. And in those cases, that's that if the seller has within the previously 6 months obtained such documentation, then they would be required to provide it to the buyer. And that's going to be somewhat rare. It's not going to happen too often. Now, you can provide it within 7 days of acceptance of the contract. 3 is local vegetation management in effect, and the buyer shall obtain documentation compliance with defensible space law. Again, there's very little localities that require proof of compliance with state law as a point of sale requirement. Local vegetation management may in fact be in effect. It's in effect much of LA and much of San Diego counties, but not proof of compliance. That's the key phrase to keep in mind there. And then finally, local vegetation ordinance in effect, and the seller shall provide documentation. That would be if you have a house in Truckee, according to Car Legal, all the Truckee people are going to be checking box B4 or 4B4. Why? Because they have a local ordinance that requires that you prove you're in compliance with defensible space law as a point of sale requirement. So that would be the case in some areas of the state, but very few areas currently. Now, that could always change. Now, here's the problem. Car Legal has discovered, and one of our agents actually discovered the same thing accidentally. Cal Fire is misinforming the public. On their website right now, it says to sell your house, an inspection is required. Car Legal has appealed to Cal Fire to remove that from the website. They emphatically state that that is not a requirement. I read the ordinances, the civil code, and Cal Legal, of course, is correct. They know what they're talking about. Cal Fire, if you call them on the phone, they may well tell you, yeah, you have to get an inspection. Not as a point of sale requirement. That's the point. And so I want to sort of alert you of that, to be very careful. Now, that doesn't mean you're not supposed to comply. It's just, just like the low flow plumbing fixtures, you're supposed to have them, but you don't have to prove you have them to sell your property unless you live in certain portions of LA County, city of LA actually, and certain areas in San Diego County, specifically the city of San Diego. All right. So, that, again, that's the local ordinance requiring proof of compliance. That's the unusual circumstance currently. So I wanted to sort of bring everybody up to speed on that. The seller is making a representation to the best of their knowledge. And so, don't stress out too much if the seller doesn't know for sure. To the best of their knowledge, what do they know? And then finally, the buyer acknowledges a receipt and agrees to the terms in 4B. And that means if anything needs to be done, the buyer will take care of it within 1 year of close of escrow. Okay, so that completes that little reminder. Today, I want to talk about some challenges that agents are facing in the current market that are causing a little bit of a few problems. I'm getting a lot of questions, and there's an opportunity to get yourself and your client in trouble if you aren't being careful about how you address some of these situations. And the specific situations I want to talk about, time allowing, is number one, paying over appraisal, removing appraisal contingencies, and agreeing to pay X number of dollars over appraisal as part of the condition of your offer being accepted. So I want to review that. I've had at least two, maybe three, actually three specific situations where it was a little problematic because the addendums talking about paying over appraisal were not worded as well as they could have been. And it caused some confusion and, of course, possible liability to a seller. And that we don't want that, of course. The other thing I want to talk about is adding a buyer to the contract. That is frequently done incorrectly. There's a very specific way to do it. And as you're going to see in a moment when I cover that, there's a benefit, a huge benefit to the seller to adding a buyer correctly or assigning the property correctly. By the way, adding a buyer is legally an assignment. What is happening is the buyer, if mom and if junior and wife buy a house and they decide to add mom to the contract, then what they're really doing is assigning the contract to junior, wife, and mom. So they're sort of restating or redefining who the buyers are. And that's exactly what an assignment is. So you'll see what I mean when we cover that. And then finally, I want to remind everybody, I'll go through it kind of briefly, but the correct way to cancel a transaction and how to sell a home where you are in the midst of trying to cancel a previous transaction. It's how you do it in a way that you don't end up selling the home twice. All right. Of course, any questions, don't hesitate to contact me. Always happy to help, of course. All right. Challenges in today's market, especially appraisals, assignments, which is, like I said, includes adding a buyer to the transaction, and cancellation. So let's look at them one at a time. Appraisals. And specifically, what I want to look at is when a buyer is willing to either waive the appraisal contingency or pay over appraisal. Maybe they want to limit how much they'll pay, but how should that be handled? So we're going to look at the appraisal contingency and paying over appraisal. We covered this recently, I think in April, actually. I modified one of the clauses that I'm going to recommend if you use it, the correct wording, as a result of some challenges that we have faced in a buyer agreeing to pay over appraisal, and then how the seller inadvertently might end up being in a position to maybe have to reduce the price to match the amount the buyer is willing to pay if it's not enough to cover the entire purchase price. You'll see what I mean in a moment. Okay. So the appraisal contingency and paying over appraisal, the buyer should consider what will happen if the property doesn't appraise for the purchase price, because if they're going to be removing their contingency or agreeing to pay over appraisal, they're not going to be able to borrow that money if they're getting a loan. They're going to have to make up that difference in cash. So the question that a buyer should first ask themselves, and of course a seller should confirm, does the buyer have sufficient cash to make up the difference between a low appraisal and the agreed to purchase price? If the buyer is unable or unwilling to make up a potentially large difference, the buyer should consider modifying the appraisal contingency, but not removing it in its entirety. So there's four ways to deal with the appraisal contingency and the ultimate purchase price. One is simply removing the appraisal contingency. That's real simple. Show you how to do that in a moment. Removing the appraisal contingency and agreeing to pay the purchase price. That's a little bit more binding. But it's not much difference than option one, because if you remove the appraisal contingency and don't pay the purchase price, you could be subject to losing your deposit as a result of a default. Lowering the appraisal contingency threshold. This is by far the safest way, especially for a buyer and frankly for a seller too, to deal with a buyer who is willing to pay over appraisal. Or if you really want to memorialize some dollar amount that the buyer will pay over appraisal, but not more than the purchase price, how can we do that? So let's look at those four options. Paragraph 3I, that's not 31, that's 3I of the RPA contains the appraisal contingency and removal paragraph. It's a very simple, short paragraph, and its default is the agreement is contingent upon an appraisal. By the way, that 3I is part of every RPA unless it's counted out, or if you check the is not box. I'll cover that in a minute, including all cash offers. All cash offer can still get an appraisal, and unless this has been removed or modified, they can cancel as a result of the property not appraising as well. All right, so number one, simply removing the appraisal contingency. Well, you go to the appraisal contingency paragraph 3I and simply check the box. Well, how simple is that? Now there is no appraisal contingency. And of course, the buyer is not obligated to pay over appraisal. He's not saying he will. He's just saying he won't have a contingency if it doesn't appraise. And of course, the buyer could lose the deposit if the buyer canceled because of a low appraisal, because by checking this box, they've removed their appraisal contingency. All right, removing the appraisal contingency and agreeing to pay the purchase price. That's a little stronger offer from a seller's perspective. They're going to like that just a little bit better than option one. From a buyer's perspective, it's really not much different than option one, because if you remove your appraisal contingency and then cancel as a result of not getting the appraisal you were hoping for, you could lose your deposit, as I stated. So again, you start with the appraisal contingency and removal, and you check the box. It's not contingent upon a written appraisal. And then you would add the following in an addendum or in your counter offer if you were countering it back, but usually this would be provided by the buyer. And in the addendum, you would say this agreement is not contingent upon an appraisal of the property. Buyer shall proceed with the purchase at the stated purchase price without regard to an appraisal valuation of the property. I'll make this available. I'll give this to Lindsay this afternoon, and she'll distribute this to everybody, so you'll actually have this language in front of you. This is the exact same language I covered in April, but I am going to make an important change in one of the clauses here in a moment. The second clause, you would say, is in the event the buyer is financing all or part of the purchase price, buyer shall make up the difference in cash. So that's pretty simple. Lowering the appraisal contingency, that is the safest way to deal with a buyer who might be willing to pay over appraisal, and you can limit it to how much you will pay over appraisal by simply lowering the appraisal contingency, not removing it. So, the important point is, first of all, the appraisal contingents and the removal paragraph, you do not check any box. So the appraisal contingency stays. However, you modify it, and you modify it with the following statement. The first sentence of paragraph 3I, excuse me, shall be modified as follows. This agreement is contingent upon a written appraisal of the property by a licensed or certified appraiser at no less than X number of dollars below the purchase price. That is the amount of money the buyer is willing to pay over appraisal. So if the buyer was willing to pay over appraisal, then 15,000 would go in that blank if he was willing to pay 15,000 over appraisal. If he's willing to pay 10,000 over appraisal, he would put 10,000 in that blank. Now, so that is simply, the easiest and simplest way to deal with it is to modify the appraisal contingency, and then the buyer can elect to go ahead and pay that money even more if he chooses, but he's not obligated to pay more and won't lose his deposit if he needed to pay more. So it appraised 20,000 less. He was willing to go up 15,000. He could cancel because he doesn't want to come up with that extra 5. Now, the more popular clause although I think it's far less risky because as I've modified it. So this clause here has been changed from the April presentation. And this is where a buyer is agreeing to pay X number of dollars over the appraisal, not more than the purchase price. And he wants to state that affirmatively. So again, the appraisal contingency and removal do not check a box. So the appraisal contingency still exists, but you're going to modify it because he's going to pay, 15,000 over appraisal, but not 20 over appraisal if that were the case. So on the addendum, you modify the appraisal contingency just like you did in number 3. The first sentence of paragraph 3I shall be modified as follows. This agreement is contingent upon a written appraisal of the property by a licensed or certified appraiser at not less than, and if you are willing to pay 15,000 over appraisal, 15 would go in that blank. If you're willing to pay 20 over appraisal, 20 would go in that blank. 10, whatever the number is, that's what would go in the blank. Now, this is important. Don't screw up clause 2. Clause 2 definitively protects the seller from some inadvertent reference to the fact that the purchase price will be reduced because the appraisal came in low. For example, and I'll read 2 in a minute, but let me tell you what not to write. Buyer to pay 15,000 over appraisal. The risk to that, although Car Legal feels like you probably would prevail, but Car Legal will tell you the risk of writing a statement like that. I didn't print it here because I don't want it written where you inadvertently think to use it. Buyer to pay X number of dollars, 15,000 over appraisal, up to 15,000 over appraisal. So it appraises it at 20,000 below purchase price. Well, the buyer to pay 15,000 over, and that's what the purchase price will be. And I can tell you, buyer's agents are going to read it that way. So you're going to have a problem if you don't write this clause correctly and write it just like this. In the event the appraisal comes in below purchase price, buyer agrees to pay, in my example, 15,000 over appraisal, but not more than the purchase price. Okay, because that's, that protects the buyer. In no event shall the seller be obligated as a result of this clause to reduce the purchase price below the amount stated in paragraph 1C of the RPA. For those of you that aren't intimately familiar with the RPA, 1C is where you write the purchase price, right there at the top, right after you write down, who the buyer is and what the property address is. They agree to purchase the price. It's written in 1C. So in no event shall the seller be obligated as a result of this clause. I don't want this to confuse what the purchase price will be. It will not be altered unless it's altered by a separate buyer and seller executed addendum. So this is very important. I want to be sure everyone understands if you are still involved in transactions with the buyers agreeing to pay over appraisal, you want to memorialize it in this way so that you don't inadvertently imply that the price might be reduced to the seller. All right. Now, the seller can always reduce the price, and if they choose to, and that's through an addendum. We had a situation where we actually had that kind of an argument. We were, I don't remember exactly now, but I think we were like 30,000 apart. And the buyer insisted that he agreed to pay, 20,000 over appraisal, and so the seller had to come down 10,000. And the seller did end up coming down a little bit, and the buyer ended up coming up a little bit. But that argument was, had, possibly weak merit, but enough merit where we advised the seller they might want to seriously consider negotiating an agreement with this buyer. If this clause were in that agreement, the agreement said sale buyer to pay X number of dollars over appraisal. That was not the best wording. And had this been in there, in no event seller be obligated to reduce their price below the 1C number. the seller would have been in a stronger negotiating position. All right. So, and then of course you add, in the event the buyer is financing all or part of the purchase price, buyer make up the difference in the amount financed and the purchase price in cash at closing. All right. Now, I want to just remind everybody, in case people look at just this particular webinar, about the appraisal contingency and the amendatory clause. We talked about it before. If in fact the loan is an FHA or VA loan, then the FHA VA clause kicks in. And of course, the key is for this clause to kick in, you have to specify in these blocks, it's either an FHA or VA. If you're getting a VA loan, but you didn't check one of these boxes, you do not have the protection of an amendatory clause requirement in the agreement. You know, the lender's going to require it, but the seller isn't obligated to sign it unless one of these boxes are checked, either VA or FHA boxes checked. Because if they are checked, then the amendatory clause is part of the agreement. And of course, the amendatory clause basically states that notwithstanding any other provisions in the contract. What does that mean? That means even if you agreed to pay over appraisal, even if you remove your appraisal contingency, none of that matters. Notwithstanding any other provisions in the contract, purchaser shall not be obligated to produce to purchase the property if it doesn't, or lose their deposit if it doesn't appraise at the purchase price. And that's what you write in the blank there, the purchase price of the property. Okay, now, again, if you represent a buyer, you should advise the buyer that there are risks to fooling around with this appraisal contingency. You might have to feel like you have to do it to get your offer accepted in today's market. It's still pretty competitive out there. A buyer's agent should at the very least advise the buyer that there are risks in paying over list price. There are risks at removing or reducing the appraisal contingency. And you can use the MCA to accomplish that. Review the MCA with the buyer, especially market conditions, offering price, non-contingent offers, and appraisal contingency. And then, of course, it's the buyer's decision alone. We're not recommending to a buyer to remove an appraisal contingency. The fact that we're reporting to them that, you know, sellers are not accepting many offers unless you remove it. If that's what you're telling the buyer, make sure you phrase it in that fashion. Don't say, so you should do it. No, he makes a decision. You're simply reporting the facts. And the sellers are requiring appraisal contingencies to be removed. I don't know that all sellers are doing that. I'm just making that as an example. And of course, the buyer recommends that you do not goof around with the appraisal contingency. Okay, so that completes the review of the appraisal contingency and paying over appraisal. I think I'm on schedule. That's good news. I now want to talk about adding a buyer to the transaction or assigning the transaction to a new buyer. This is very important to do correctly because there are significant protections to a seller and to the agents involved in the transaction, especially the listing agent, if this is done correctly. And I would argue also protection to the buyer's agent, because a buyer could inadvertently be obligated to do things they didn't think they had to do, and it wasn't explained to them well. If they execute a assignment, then it's going to be explained to them by virtue it's on the form. So you'll see what I mean here in a moment. So the residential purchase agreement, page 9, paragraph 26 discusses assignments. And again, assignments include adding a buyer. If buyer A and buyer B are going to add buyer C, legally what they're doing is they're assigning their interests to themselves plus C. That's legally how they bring C in. And doing an addendum, buyer C added to contract, is frightfully dangerous, because there's all kinds of things that are not covered by such a thing. And it's actually not legally correct. And interestingly enough, it's not per the RPA. If the buyer is going to assign this interest as agreement in any way, any part of his assignment. So obviously one would say that, buyer A and buyer B, maybe they have a 50-50 share. Now they're going to bring in buyer C. Well, they might have a 33% share now. So they're giving away, buyer A and buyer B are giving away part of their interest to buyer C. The buyer shall not assign any part of the buyer's interest in this agreement without first obtaining a separate written consent from the seller to the specified assignee, and that consent can't be unreasonably withheld. The seller can't just arbitrarily say, nope, I'm not going to let you do it. So if a buyer and a seller want to add mom to the contract, you're going to have a hard time not letting them do that. If the buyer and the seller, if the buyer and if the two buyers want to add mom, not the buyer and the seller, if the two moms want to add mom, oh, I got all mixed up. If the two buyers want to add one of their mothers to the contract, seller's not going to prevail in objecting to that. If the two buyers want to add a derelict, ne'er-do-well, unemployed person, that might be problematic, but that's probably not going to happen too often. So generally, these assignments will be agreed to because you can't unreasonably withhold agreement. And it's accomplished with Form AOAA, Assignment Agreement. So it's the Assignment Agreement Addendum. And it's a single page form. We're going to look at it in some detail here. And this is how you add a buyer. And you'll see the form's even designed for that. So it should be real clear once you look at the form. Whenever we suggest to somebody, how do I add a buyer? Use the AOAA. They frequently will let me know, oh yeah, it's pretty straightforward. I see it. And it is, as you will see in a moment. So first thing I want to point out is, we'll go through the form in detail. The buyer and the seller, on the top of the form, these blanks are filled in with the original buyer and the seller. This is not the new buyer. See, the buyer is defined in the RPA. Up in the top of the RPA on page 1, Bob and Mary Smith, and then in parentheses, behind their name in quotes, buyer. So now everywhere the word buyer appears in the contract, that means John and Mary Smith. So again, you would name them because they are the named buyer. The assignee is not a part of this contract yet. So the assignee's name, the person they're assigning it to, the person they're adding, does not belong on this first blank. That's frequently misunderstood. Of course, the seller is pretty straightforward. That goes down there. Okay, now look at the next item here, paragraph 1, partial assignment, adding a buyer. So the buyer, a buyer up here, Bob and Mary, if that's the name I used, Bob and Mary are adding the assignee named below to the agreement, and are granting the assignee a partial interest in the agreement. So they're adding somebody to the contract, and they now have an interest in the property. So that's typically how you simply add a buyer. Now, if you're getting a new buyer or deleting a buyer, then you would check B. So sometimes flippers will buy it under one name and then want to assign it in total to a new entity. Well, then you would check B, and then you would name who the assignee is. Now, if it's a total assignment or deleting the buyer, you would check B, and then the assignees would be the remaining buyer. Because Bob and Mary are assigning this property to Bob only. Why? Because Mary has an interest in this property. When I bought my house, my wife, I don't want to be too personal, but if anybody should have the best credit in the world, it would be my wife. She is phenomenal with handling money. And many of you who know me know that I preach that all the time. Here's what's interesting about my wife. And I don't fault her for it because, I'm not in debt because of it. She does not believe in debt. The only debt she believes in is the mortgage. And even that drove her crazy until it was paid off. Her sole purpose, as far as handling the budget, was every nickel we had to go to paying off the house until we got it paid off. Here's my point. When I bought the house I'm in now, of course, Diane and I bought it together. But then the lender said, Walt, worse than bad credit is zero credit. My wife doesn't appear on any TRWs anywhere. As far as the credit agencies are concerned, she doesn't exist. Why? Because she's never bought anything on credit in her life. So the deal is, then I had to delete Diane from the contract. And of course, we had an understanding that we immediately added her back to the title after close of escrow, so she's not crazy. But we had to delete her from the contract because the lender would not loan me the money because Diane, they couldn't find her in the credit bureau. Okay, so the reason I'm telling you this story is Diane has an interest in this property. So Diane is named as the buyer as well as Walt. So Walt and Diane are assigning the property only to Walt. And Diane's interest is now no longer a part of this transaction. So that's the rationale, the legal explanation of why you would use this assignment to delete a buyer. You should not do an addendum. Diane is hereby deleted from contract. What's that mean? That's not nearly as safe and correct. It's not at all correct. So I'm preaching a little bit, but I just want to be sure everybody understands, because intuitively most agents don't go to the assignment when they're adding or deleting buyers. They think doing it by an addendum. Car Legal will tell you it's wrong. It is, in fact, contractually very bad to simply use an addendum. This is an addendum, but it's an assignment agreement addendum. All right, so let's look at paragraph 2 and 2 through 9. That is where the meat of all this assignment really exists. This is where the protection to the seller exists. So the assignee, now remember, that is the person being added to the contract or the person who's taking over the contract. So the assignee acknowledges that the buyer has already provided the assignee all the transaction documents that they have previously approved. And of course, they go on to list them, including but not limited to the documents, the inspections, the reports, the pamphlets, the advisories, the disclosures. So the buyer is stating, and the assignee is stating that the buyer has given them everything to date. And you want that, of course. And the next thing, very important, the assignee, that person being added to the contract, within 3 days or blank, will deliver to the seller signed copy of the seller who signed the copy of the agreement, a signature on all prior documents. So the assignee will initial, sign, and deliver to the seller all the prior documents. So, and those of you who've added buyers, and you know it's a nightmare. TCs hate it. 2 days before escrow closes, we got to add a buyer. Well, every single disclosure has got to be signed by that new buyer. Believe me, that's critical. We've had claims filed against us, and in one case, we actually paid to avoid a lawsuit. A buyer was added and claimed they never got one of these documents, and they didn't add them with an assignment. Of course, we maintained they did get the document, but they said they didn't. One of them got them, but the other one didn't. So it's a problem. But this now says that the assignee will sign everything that's already happened in the contract, or they've already signed everything and are attaching it to this agreement. So a real proactive agent says, okay, we're going to add mom to the contract. So I had mom sign all the disclosures. Here you go. So that's certainly an option. I can tell you, I don't see that very often, but that's one way to do it. Now, if this is very important, because we want that assignee to be on record, especially on those disclosures. If the assignee does not deliver these signed documents. Remember, that includes all the reports, the inspections, the pamphlets, the advisories, and the disclosures. The seller may withdraw a consent to this assignment, and the assignment won't be enforced. So that person who's being signed to doesn't get to be one of the buyers. So this paragraph 2, I can't stress to you how important it is. And when agents add a buyer by an addendum, it's much more difficult to convince the buyer's agent from a different brokerage, no, your buyer's got to go back and sign. The person you assigned it to, the assignee, that mom who you added to the contract, she's got to sign everything. No, she doesn't. Escrow did a document. She acknowledges and agrees to everything. Well, but the problem is everything's not defined. You haven't listed every document, the date of the document, how many pages are on all those documents. By the time you do all that, why don't you just sign the document? I've had this conversation many times. Whoops. And again, I'm a little bit handicapped. I don't give up easy. Most of you know that. But I am a little bit handicapped when we're dealing with an addendum that simply says, mom is added to contract. But when it's done by an assignment, we got some teeth in it. Okay. Now, the assignee represents for the benefit of the seller that the assignee approves everything that was done prior by the buyer. That's very important. The assignee assumes and agrees to perform all the obligations of the buyer now moving forward. That's fairly important. Buyer acknowledges and agrees that the buyer is not released from any obligations under this agreement. That's, again, very important. So you assign it to somebody, and then that somebody can't perform. You do it with an assignment because you can go back as a seller and say, okay, original buyer, you're responsible. You assigned it to somebody we didn't know, they couldn't perform. We couldn't know that. So now you're back on the hook. So paragraph 5, all of these paragraphs are critical. They really are. So I'm preaching a little bit, but it's only because in the last few weeks, we must have come upon 3 or 4, just in the last few weeks, 3 or 4 adding buyers by a simple addendum, and that's not the right way to do it. Okay, now the seller has been advised that the buyer either has or has not received money for this assignment. That is important. And then, without releasing the buyer of any obligations, the seller consents to the assignment. And the parties acknowledge that they've checked with their own attorney and that brokers make no representations as to the propriety, the adequacy, the legality, the tax consequences of the assignment. So that, sort of a disclaimer that protects the broker. So that's critical. All of this 2 through 9, you want as part of the quote, adding a buyer to the contract agreement. And the way to do that is always use an assignment, AOAA. Now, the buyer signs it. The assignee assigns it. See, that's the other problem with these addendums. Bob is added to contract. The buyer signed it, the seller signed it, but did Bob sign it? Where's the assignee's signature on this simple addendum? Often it doesn't appear. Bob's not obligated anywhere. So with the AOAA, the assignee is also signing because he's agreeing or she's agreeing, and of course the seller signs it. Okay, that concludes the adding a buyer. And I'm going to try to zoom through the canceling of a contract. Again, it's a review, so I should be able to get through it fairly quickly, and we'll wrap up and then get some questions. So if you got some questions there, hold them for a moment or two, and then Lindsay will help me with that. Okay, so how do you cancel a purchase contract? And of course, the escrow that goes with it. And we're having more cancellations, and I'm reminding agents all the time to be very careful and do it correctly. And sometimes agents jump the gun a little bit. They don't follow the actual procedures that the RPA specifies that they follow. So let me walk you through that real quickly. To cancel a purchase contract for non-performance by the other party, and frequently it's going to be the seller canceling the buyer because the buyer is not performing in one way or another. You must first give notice to the other party. Depending on your reason for canceling, the notice might be a notice of buyer to perform. It might be a notice of seller to perform because the buyer's canceling. And then finally, it might be because either party's not closing escrow like they're supposed to, and it might be a demand to close. I want to say this now. I'm sure it'll come up in a moment, but if it doesn't, you never, ever, never use a notice of buyer to perform or a notice of seller to perform to compel a closing. First of all, the contract says you don't do that. The contract requires a DCE. Second of all, the notice to buyer to perform is problematic because it calls for the buyer if the buyer is the one who's not performing, it calls for the buyer, if you cancel pursuant to a notice of buyer to perform, it calls for the buyer to get the deposit back. So, that makes sense if you want the buyer to remove contingencies and he won't. Well, then you give him a notice of buyer to perform to remove contingencies and he doesn't. Well, then you could cancel. But of course, he would get his deposit back anyway. And the notice of buyer to perform says the buyer will get his deposit back. It says that even if you use it to demand a closing. And of course, the buyer could say, well, first of all, correctly, by the way, first of all, the contract says you got to give me a DCE, not a notice of buyer to perform. So you haven't given me a notice. And second of all, even if I thought you did, then I get my deposit back. And that could be problematic. So only use a DCE to compel a closing. All right. So the notice of seller to perform, the buyer to perform. I'm not going to spend a lot of time on it. Everybody's fairly familiar with it. There are two sections to the form. One is section 1, which are all the contingencies listed, and there's quite a few, and there's some blanks for extra ones. A mistake that agents make is they check box I and they write a contingency here that doesn't exist. And so you're making a mistake because you've removed all your contingencies because the contingency you didn't remove, I'm sorry, I'm ahead of myself. That's on the contingency removal. So negate that. Okay, the contingency, the notice to buyer to perform, Kenny might be able to edit that out. The notice to buyer to perform has two sections, contingencies and contractual actions. So there's a bunch of contingencies listed, and you have the option to list a few more. Or contractual actions that the buyer is supposed to do and they didn't do it. So you can also check one of those boxes, check all that apply. If the buyer doesn't remove the contingencies or perform the action within boilerplate 2 days after delivery, but no less than the time specified in the agreement, and I'll point that out to you in a moment why that's important, the buyer may cancel. So everybody pretty much understands that pretty well. And many of you on this call know about a little trick. I call it a trick. I don't call many things I do a trick, but that's kind of an interesting little trick. Under the time periods and removal of contingencies, paragraph 14E, that's where the boilerplate of 2 days exists. I've been teaching for years to plug in 3. Larry's told me that he's had agents successfully plug in as many as 7. Now, here's the key. If you plug in 7, I'm sure the chances of that getting caught increase slightly. And if it is caught, they're going to change it back to 2. I've had sellers see the 3 and say, oh, what the heck? I don't care because it's only one more day. Now, why is that important? Anecdotally, I can tell you this. I've been involved in lots of discussions regarding contingency removal over the years, hundreds. Anecdotally, most notices to perform are not delivered until Wednesday or Thursday or Friday. It is not common for a notice to perform to be delivered on a Monday or Tuesday. That is simply an interesting little quirk. Why is that? Because a lot of agents don't want to deliver a notice to perform because they don't want to offend the other side. They want the other side to perform, but gee, if we give them a notice to perform, they'll get mad and maybe they'll cancel, which is bad logic. No, you should give them a notice to perform. So if you put in 3, you have a fairly good chance. I'm not exaggerating. You have a much better than 50-50 chance. You probably have a 75-80% chance. If you're going to get a notice to perform, it'll be on a Wednesday maybe a Thursday or a Friday. Now, if it's on a Thursday or Friday, it doesn't matter as much. But if it's on a Wednesday, when you count days, you cannot count the day the notice is delivered, and you cannot count the last day if the last day is a weekend or holiday. So think about this. I get a notice to perform on Wednesday, and I changed 14E to 3. Thursday's day 1. Friday's day 2. Now, if I didn't change 14E3 by midnight or by 11:59 p.m. on Friday, I got to remove those contingencies. But if I plug in a 3 here and get away with it, I get the notice on Wednesday, Thursday's day 1, Friday's day 2, Monday is day 3. I've just bought an entire weekend. Now I have 5 days to stew about this, and I'm much better off than just the 2 days that I might have gotten. Now, apparently, the Rules Committee has been burned on this. One of the members of the Rules Committee is a Fallbrook broker, and I think his office has stumbled onto our little trick a few times because the new RPA, I believe, takes out this option to modify the number of days. I think that's sad. We'll see. When the new RPA comes out, I'll know here in another month. I'm scheduled to take a day-long class on it, and then I'm going to be teaching it to everybody after that, so you're all familiar with the new RPA before it's actually released. Okay, so notice the seller to perform, same thing. They have contractual action. Now, there's a lot more contractual actions than there are seller contingencies, and the same, you remove them in 2 days after delivery, or if it's modified, or the buyer can cancel. Now, if you are canceling because the buyer is not closing or the seller is not closing, if you want to compel the buyer or seller to close, of course, you have to compel them to close first. You would give a demand to close escrow. And so we'll take a look at that. The demand to close escrow, the first section is the seller is demanding the buyer to close escrow. Now, the minimum amount of time to give a buyer notice is 3 days. That's the minimum amount of time. That's by law, and so you can't change it to less than 3 days. You can make it longer, but you can't make it 3. I sometimes see 2 in here. It can also not be earlier than the agreed to close of date, whichever is later. It says not earlier than 3 days or the close of date. So if you give a demand to close escrow today on an escrow that's supposed to close on Friday, well, day 1 is Thursday. Day 2 is Friday, but you can't say Friday because you have to give them 3 days, and the last day can't be a weekend or holiday. Obviously, you can't close on a weekend anyway. So they would have till Monday. The 3 days is there as a result of case law. The courts have maintained that a reasonable amount of notice must be given before a principal cancels on the other principal for failure to close. And the minimum amount of time that's ever been held in court is 3 days. So that's why CAR uses 3 days. Or you can do it by such and such a date. Now, you can't give a demand to close escrow the day after escrow closes, but you could give it a week early. If I want to close on Friday, for sure, I could give a demand to close on Monday and put down Friday. You got to close on Friday. That's the date you say you would close. And here's your at least 3-day notice. So you can do that. Now, the buyer is the same way. It just, goes just, from the buyer to the seller, but the same parameters exist. And then, of course, there's a confirmation of receipt so that when it's served, you can confirm the other side got it. This is not necessary to establish that it's been served. If you've emailed it, then you have a copy of that, or they've responded to your email. They frequently do that. That'll be your proof they received it. So this is nice to have. It's not required. All right. Now, once you've given either the demand to close escrow or a notice to buyer to perform, and they still aren't doing what you want them to do, what the contract requires them to do, then you could cancel the contract. And of course, the cancellation of the contract has two sections in it. One is the reason for canceling. So either the buyer wants to cancel or the seller wants to cancel. Sometimes it's both the buyer and the seller. I have a pet peeve. I don't know that it's all that bad, but I don't like the record to be inaccurate. So the buyer is refusing to close. And so the seller wants to cancel. So, but he doesn't want the buyer to be upset or try to claim that he's, the seller's acting unreasonably. So the seller will then check both buyer and seller want to cancel. Well, that's not true. Buyer doesn't want to cancel. He's just not closing. So, I only check both buyer and seller. If both agree, look, it ain't working, let's cancel. The buyer calls up and says, hey, I can't get my loan, and I know, and I don't want to tie you up, and I got a problem on my taxes that I got to fix, and that's going to take at least 6 months. So, I understand. You don't want to wait 6 months, do you? No, I don't. No, I understand. So, and then, that'd be wonderful. Check both. They both say, yeah, let's cancel the agreement. Now, A is usually the reason you're going to check. And again, most of you have been with me before know, never give a specific reason. Always cite the paragraph in the contract that allows you to to cancel. Sorry. So, paragraph 14, a good faith exercise of paragraph 14 or paragraph 10 or whatever paragraph you're using, paragraph 3I, property didn't appraise. Pursuant to paragraph 3I, I'm going to cancel. So that's usually what you put in there. Now, if the buyer hasn't removed contingencies, you can check that. If the seller hasn't removed contingencies, you can check that. Or if the other party hasn't closed. And then, of course, if both buyer and the seller agree, it doesn't really matter the reason. You can just check per mutual agreement. But again, make sure that's a fact and not trying to sugarcoat the situation. All right, now the bottom half of the form is the release of deposit, and that's also pretty straightforward. There's one little caveat. I've talked about it before. I want to remind you of it. A is the seller is going to release a deposit to the buyer, less the buyer's fees and costs that the buyer might owe in escrow. Or the buyer is going to release a deposit to the seller, less the fees and costs that the seller might owe. But the release of deposit won't be greater than 3% of the purchase price if liquidated damages has been initialed and deposit's higher than 3%. That's the most that you can keep. So that's the more common ones. Actually, D is more common, but I don't want you to check D as a rule because you got a problem with D, and I'll explain that in a minute. Sometimes you're fighting over what to do with the deposit, but you agree to let's go ahead and do the cancellation anyway, and then we'll figure out the deposit later. That's a very seller-friendly box to check because now the property is totally no longer, spoken for by anybody, and they can sell it without using a backup offer addendum and move forward if the buyer and the seller agree to cancel, and the only thing that they're figuring out is what to do with the deposit. It's not a very buyer-friendly box to check. So the buyer might use the fact that this offer is still not canceled yet, this escrow is still not canceled, as leverage to try to get the seller to be cooperative about, or be reasonable about releasing the deposit. So see if you're a seller is great, not so much if you're a buyer. D should not be checked. And the reason is, I want to try to wrap this up. I think I got a slide on this, but I'm going to use this slide here. If you look at down below, a lot of agents don't realize this paragraph exists, and it's pretty important. If A or B are checked, buyer and seller release each other, period, from anything. We're done, and that's important. A lot of times agents will check D because they're afraid that the escrow company is going to charge them a cancellation fee. It is rare that an escrow company charges cancellation fee. Here's how to handle that. Call up the escrow company. Escrow companies don't want to alienate buyers and sellers agents by charging their clients cancellation fees. So I can tell you, I don't think we've charged a cancellation fee at Escrow One, and prior to that, Remax United Escrow, more than once in 20 years. And even then, that was for a very good cause, good reason. So that's not going to happen very often. Simply call up the escrow company and say, is there a cancellation fee? I'm sure there isn't, right? And then debate with the escrow company. If they think there is, try to get them to agree no, so you can check either A or B. Because if you check D and say entire deposit of buyer deposit shall be refunded to buyer, the problem with that is, number one, you don't need it, I would argue. Number two, if C or D is checked, buyer and seller reserve the right to go after each other for any obligations or damages that the other party suffered other than buying the property or selling the property. So a buyer could sue a seller, theoretically, for expenses they incurred in the escrow. A seller could sue a buyer for expenses incurred as a result of this escrow not closing. I mean, you still have to take a legal action. But the right to do that exists if you don't check A or B. So I submit there shouldn't be any cancellations that don't have A or B checked. However, we don't make up the principal's mind, but that should be explained to them. Usually, though, it's the agent who suggests writing this entire deposit of buyer shall be refunded with, and then, later the buyer finds out, oh, the sellers can take me to small claims court. I thought this thing was over. Well, your agent didn't protect you because he checked box D. See, so don't do that. All right. So I think the only last thing I'll cover, and then we'll wrap it up here, is on backup offers. If you do not have a completely executed cancellation, as long as one party has signed the cancellation, so the seller has signed the cancellation, buyer hasn't, seller can put the property back in the MLS. The seller is always allowed to accept backup offers. I could sell a house to Bill Gates today and accept 10 backup offers behind his offer, just in case Bill Gates decides he doesn't want to live in San Diego and he cancels on us. So I don't need any derogatory, problematic, or whatever issue with the current escrow to accept the backup offer. So your right to accept backup offers always exists. I would argue that backup offers rarely benefit sellers if you have a perfectly good escrow, because you are obligated, if that escrow does fail, to go to the backup offer. So what does that mean? So you've got an escrow that's working just fine. You have you're not trying to cancel. And somebody says, can we put in a backup offer? And the seller says, sure. So you put in a backup offer and you put it in, maybe at the same price as what the first offer that's in escrow is at. And you accept it. The buyer can cancel their backup offer at any time. The seller cannot. So you're in the middle of this perfectly good escrow, and then, oh my gosh, a little bump. Now another bump. Uh-oh, it's starting to get kind of rocky. Uh-oh, this first offer is falling apart. And somebody finds out about it and they say, oh, I have a buyer. They'll pay you $10,000 more than that backup offer you got. Well, you can't go to that offer until you deal with the backup offer. The backup offer's in line next, and they have every right to buy that prior to this other person, this third person, if you will, who might be willing to pay even more. So usually sellers don't benefit from an executed backup offer unless they're trying to cancel the first one. Now they want a backup offer because they don't want to be obligated to sell to the second one if they can't get a cancellation on the first one. Hope that's not too confusing to you. So the backup offer addendum, pretty straightforward. We've been through it. The position of the backup offer, let me go back. You want to make sure that's filled in. What number is this backup offer? If this is the first one, then one should go in there. If it's the second one, or likewise a third one, don't think you'll have that many. And the buyer's deposit, the default is will go in 3 days after written confirmation the first offer is canceled, or it could be go in immediately. And then time periods. The default is time periods won't start until after seller delivers cancellation of the prior contract, or they could start immediately. So, to start them immediately and to deposit the money immediately, to require the money to be deposited immediately, you got to check the boxes. Otherwise, nothing gets done until the first offer is fully canceled. But if the first offer can't get canceled and it gets resolved, the seller has the right not to sell the home to the backup offer and has no liability to the backup offer because the offer was accepted contingent upon the successful cancellation of a prior offer. And of course, the bottom of the form then has a place where you can notify the person who made the backup offer that you now have full cancellation, and you can attach a copy of the cancellation as you deliver it. And now the second buyer's contract is in force. That wraps it up, folks.
We don't have any questions, but Sharon made a statement saying that it's hard to market for backups from the pending status.
It is. Unfortunately, it is. Unfortunately, our rules still require us to put it in pending when we're in pending. So that is why if you're canceling, you can always rescind the cancellation. I don't want to create drama where we don't have drama, but if you have a buyer who is really concerns you that they're not performing, and you're not unwilling to give them a little bit more room, but in the meantime, you want to get a backup offer. If you have the right to cancel, I've often recommended, and you got to be sort of specific to the circumstances, but I've often recommended the seller should go ahead and sign a cancellation, send it to the buyer, tell the buyer, I'm willing to rescind this if you can take care of this problem in the next day or two. But in the meantime, it doesn't look like you can, and I want to get this home back on the market and get a backup offer. So once the seller signs a cancellation, and of course you first have to have given the demand to close escrow, or first have had to give the notice to perform. Once you've done that, now you can sign the cancellation, and whether the buyer agrees to the cancellation or not, you can now move the property back to active. And sometimes where the buyer could perform, but they're just dragging their feet, seeing that property active will light a fire under them. And then you can always rescind the cancellation 2 days later. So that's, Sharon, one way to get around that pending status. All you need is for your client, the seller, to have signed the cancellation.
I have a question from Judy Walt. If the assignee is added at the last minute, what are the timeframes to get the assignee's financials, especially if the assignee is replacing the original buyer?
Well, the time frame, the assignee doesn't have any additional, the assignee, that's a great question, by the way, and sometimes people do get confused by that. The assignee isn't starting over. You're not starting over. The assignee is stepping into the shoes of the previous buyer. If it's a total assignment, if it's adding a buyer, they're stepping into the shoes along with the current buyers. And so they have to perform under the same guidelines as the original contract. So if you needed the assignee to document their financial position, you would immediately, number one, tell them, look, we need your financials right now. You might want those financials before you even agree to an assignment. If you agree to the assignment, they got 3 days to give you everything, and that would include the financials, or the assignment's null and void. Where you don't want to get hooked up or tripped up is believing somehow that time frames, we got a new buyer, so now do the time frames, do they get 14 more days, 17 more days, 7 more days? No, they don't get anything if the original buyer didn't have it. And you got an assignee who comes in on the 10th day of the contingency period, and it's a 17-day contingency period. The new assignee, The assignee has 7 days, as does the original buyer, if he's still part of the contract. Does that answer the question, Judy?
Yes. I didn't see the 3 days. I'll have to go back and see where you said 3 days, because you said,
well, the 3 days, no, the 3 days that I'm referring to, I'm sorry, is that if the buyer doesn't provide, documentation signed by them within 3 days that the original buyer had provided, the seller could say this assignment's no longer in effect. So where I'm reaching a little bit just to give you a worst case scenario. You want the buyer to sign the TDS, the new buyer. The old buyer signed the TDS, but they added a buyer. You want them to sign the TDS, and they have 3 days to give you that TDS signed by them. And if they don't give it to you, you can cancel the assignment. Now, you can't cancel the contract. You just cancel the assignment. The assignment's null and void. The original buyer must continue to perform. The original buyer gave you financials. They got, worst case, 3 days to give you financials, the new buyer, because the original buyer has already given you their financials. Now, a better way to approach that maybe is, if you're concerned, if you need the new buyer's financials to be verified, you might want them before you even agree to the assignment. Just like before you accept an offer, you want a pre-qualification or pre-approval or a verification of funds. And if you don't send me a verification of funds, I'm not even accepting this. So if the assignee is an entity, that you have some reason to want to do, they have the financial ability to do this, well, then I would suggest before you sign the assignment, you tell them, look, we want to see your financials before, whatever it is. If they're, step in and get a loan, you want their pre-approval. If they got cash, you want to see that money in an account that they control. Does that make sense?
Yeah, I think the idea would be to get those before you agree to the assignment. I would. The assignment more, not a partial, not adding mother or father, but when another LLC comes in or another buyer that you don't know them from Adam.
Right. Yeah. Exactly. Yeah. Excellent point. And I was actually thinking of that. Usually, if you're adding mom or dad, their financials aren't a big concern because they're adding mom and dad because the lender checked and said, you know what, we need mom on this or dad on this, so we have their financial clout. But you're right. They're assigning it to a different entity entirely you've never heard of. Well, you want their financials before you agree to that.
Okay, that makes sense. Okay.
Yeah. Good point.
Walt, I have a question.
Yes.
It's come up in the past, just recently, about the AOA, the adding an assignee, that if they are replacing the buyer completely, that we had discussed that it was better to just write a new contract and to cancel the prior one when they're not related. We just had one this morning where they're adding a daughter and her husband, the mother is, which that's okay. That's good to just add them. But I remember we discussed that if they're replacing a buyer completely, they're not related, they know nothing about each other. And Kenny had mentioned that to write a new contract would be better.
Yeah, and if I remember particularly, wherein that the assignee has no relationship in any way with the original buyer, somebody said, hey, you buying that house? I heard that you bought that house. You assign it to me. I'll give you some money. And you don't know who that second person is at all. Much better to have a whole new contract. If we're going to have a second person in here, I'll tell you where the assignment can be beneficial, though. And that is, the assignment can be beneficial because if they're at the end of their due diligence or something like that, the assignment doesn't give them an extended window to perform. Okay.
Right.
So there could be a circumstance where, all right, I would agree to an assignment, but I want this thing to close at the end of the week. And we've already given you all the disclosures. I don't want to start over again. And so in that case, now, if the new buyer could perform, kind of thinking through this a bit, well, then write the new contract, it could perform in that short time frame. Write the new contract with the remaining time frames as your time frames. So close in 10 days. So you could write the new contract to take advantage of how much time you spent with the old one. Yeah, but in general, if you've got a totally unrelated assignee, has no relationship whatsoever, it's not required by law, but it would be recommended they could just write a new offer.
One last question.
Yes.
If you do a notice to perform, do you have to do a demand to close prior to canceling, or can you go from a notice to perform to a cancellation?
A great question. You cannot go from a notice to perform to a cancellation without first going through. Well, no, let me rephrase that. Actually, I'm going to answer it incorrectly because I was thinking you said something else, but you didn't. If I give a notice to perform to remove contingencies, I do not need to give a demand to close escrow.
Right.
So yeah, I was hearing you, but thinking completely different. So the buyer's not removing contingencies and you want the contingency removed. Buyer's not providing you a verification of funds and you want that verification. The contract gives you that. Buyer's not giving you a pre-approval. Any number of things. So that's a contractual action or contingency removal. And if they don't perform, you give them a notice to perform, and they don't perform, you can cancel on that.
Okay.
You only have to do a DCE is if you want them to close and not so much remove contingencies. I mean, ideally, I'd like them to remove contingencies and close. But if I just want them to close, a notice to perform is the wrong form to use.
Okay.
Did that make sense? I sort of screwed it up by answering the wrong question to start with. Yeah.
Well, because the misnomer is that you have to do a notice to perform, then you have to do a demand to close, then you can do a cancellation. They have to go in that order.
Not necessarily. It depends. It depends on the situation, but I would argue that if you are simply trying to get the contingencies removed, if that's what you want, you do not need a demand to close to cancel if they don't remove contingencies. If you simply want them to close, you can give them a notice to perform to remove contingencies. And what happens if they do? You still can't cancel now because, you want them to close, but you said, remove your contingencies. Well, maybe you did that because now you get to keep the deposit. That's sort of a unique set of circumstances. But to be real clear, you do not need a demand to close if you are simply requiring the other side to do what the contract obligates them to do other than closing. So, the seller sells the home with an SPRP, seller's purchase of replacement property, but they agree to purchase that property by such and such a date. So if they don't purchase that property by such and such a date and you still want the house, you don't need to give them a DCE. You would give them a notice to remove that contingency. And then they would remove the contingency or not. And if they didn't, you could cancel, not pursuant to a demand to close, but pursuant to the fact that they did not remove a contingency that they were obligated to remove, and you gave them a notice to perform. So it's sort of a case-by-case basis, but in general, if you're canceling because the buyer won't remove contingencies, you do not need a DCE. If you're canceling because the buyer won't put his deposit in escrow, be careful with that because courts have ruled that that's not necessary, but the contract tries to make it necessary. If you're in that situation, call me and I'll give you some guidance on that. So, it's not the best example, but you could give them a notice to perform and then cancel. Why? Because they didn't perform an act. The DCE is only, look, it's time to close. You're supposed to close. I'm not stopping you from closing. So close. And if you don't close, I'm canceling. Well, that would be a DCE. All right. Well, folks, that wraps it up. I hope you got a good insight today. I hope you a review of the appraisal situation, the canceling of situation, and most importantly, all of it's important, of course, but a better understanding of how to add a buyer to a transaction the correct way. And I hope you got questions answered on the FHDS.